all tonight. I'm really honored to be here. I was really struck. Thanks to Pastor for our opening prayer. I was just really struck by this prayer for an outpouring of the Holy Spirit. And this verse came to mind. I just wanted to share with you. It's Paul, his first letter to the Corinthians. It says, "My message and my preaching were not with wise and persuasive words, but with the demonstration of the Spirit's power, so that your faith might not rest on human wisdom, but on God's power." This word has been with me for a little while. I'm just so struck that we all have God's power. So we're going to talk a little bit tonight about some human wisdom. We're going to go back to school for a little bit, but that's not where our hope is. Our hope is in God's power. We can rely on that. Thanks to Norman. This family stuff is really, really important. I'm grateful for the work he does. Hit the clicker, Norman. Thanks. So we're going to talk about religious freedom tonight.
Can you hold your mic up?
Yeah, can you? And thank you.
Okay.
Holler at me if you can hear me. Just look at this thing. So that's a picture of a hospital. I want you to imagine that you are a nurse or a doctor and you work in this hospital. Or maybe it's your daughter. Maybe it's your spouse. Maybe it's your niece. Maybe it's your neighbor. Somebody you love is a nurse in this hospital. This nurse is a person of faith, a pro-life person, and is not ashamed of that. Everybody else knows this. But this person just shows up to work one day and shows up in the operating room to assist in a procedure that they think ahead of time is going to be to evacuate a deceased child from the womb, a miscarriage. But it's not that when the nurse shows up. It's actually not a deceased child. It's a living child, and the procedure is an abortion. Think about this. What do you do? Where do you go? Are you protected in law? Is this right? Is it not? So this isn't a hypothetical situation. That's a real hospital, and the nurse is a real nurse. This really happened. It's happened many times. We're going to talk a little bit more about it when we get to the end. Where we're going to go tonight, we're going to talk about kind of where we've been federally. And I said I'm going to take you back to school for a little bit. So we're going to kind of walk through some of the history of really important cases that our Supreme Court has considered that bring us up to where we are now. And it's really important to understand because this is a bubbling issue that our Supreme Court is going to be confronted with again and again, and it's just really important for all of our rights. We're going to talk a little bit about religious freedom in South Dakota. We're going to talk about conscience, which is an overlapping and similar but not identical concept. And then we're going to just touch on next steps. Okay. The First Amendment to the United States Constitution reflects what is deeply within our identity as Americans. Like, we are a religious people. And that's not to say that we've always all had the exact same creed, etc. But from our very, very founding, we've been deeply religious. We all know the story of the founding, right? Like, freedom of religion is bound up in the very birth of our nation. It's part of our culture. It's part of our identity. It's part of who we are. Our founders recognized that this was important for the form of government that they were actually trying to enact, right? That we can't actually govern ourselves wisely and well without virtue. So we don't need to belabor the founding, but I think we all recognize this. It was certainly recognized even decades after the founding by foreign visitors to this country. One of the most famous, a man named Dakota wrote a book, Democracy in America in the 1830s, and he recognized this as well. This makes America strong. This is part of her greatness. Is this religious character to who she is. Importantly for our purposes tonight is the First Amendment. So it's not just part of our culture, our identity, it's actually part of our law from the very, very beginning. Those words, and my apologies for a bit of an eye chart, I'm going to read it. This is in the very First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So that's in the First Amendment, the Bill of Rights. The same amendment goes on to list several other very important rights: freedom of speech, freedom of assembly, right to petition your government, seek redress, right? But the first of the first, this is religion. It's not an accident. It's that important. Religion isn't just something that's sort of an incidental part of who we are. It's an essential part of who we are. And it's not just sort of this kind of, I don't know, neutral thing, do what you want, but there's a recognition that, no, it's a great good. So the question comes up is like, okay, what do those words mean? To prohibit the free exercise thereof. And we're going to walk through a couple of cases here. So, free exercise. Okay, so we've got this right to free exercise. How does this play out in, there have been like zoning cases before, right? Can the government tell you where and how to build a church? I don't know, great question. Courts have to unpack this stuff. A case we are going to talk about tonight, on the right there, that's a peyote plant. That is important as part of religious rituals for some Native Americans, and that's a signature case we're going to talk about. The important thing to recognize is that the very words of the Constitution themselves, they're the foundation, the base, and they're incredibly important, but the devil's in the details, pardon me for using that expression, but it's important because this gets fleshed out in a lot of different ways. So a lot of the case law began about 60 years ago. There's one of the first really big cases, it's still really important today, is this case, Sherbert versus Verner. And it involved a Seventh-day Adventist, one of the Carolinas, I think. And this person, Seventh-day Adventists, they don't work on Saturday, that's their Sabbath. This person worked at a textile mill, and they converted from a 5 to a 6-day work week. And this person said, I'm sorry, it's against my faith. Is there anything else you can do for me? Can I have an accommodation? Can you do something else so I can keep my job? And they said, no, I'm sorry, you gotta go. This person they were gonna change their faith. So they got let go. They then applied for unemployment through the state unemployment system, and the state said, sorry, you don't qualify. You gotta fire for cause. We all know there's for cause, not for cause. So the question was like, well, there's a state action involved here. There's this state unemployment program. Is this really for cause? Or do we have to actually respect people's free exercise? It's kind of a boring technical thing, but this is how the law plays out. All the way up until the Supreme Court, all of the courts all the way up said, sorry, your boss said work on Saturday, you gotta work on Saturday. And the Supreme Court, in a landmark case, said not so fast. Actually, religion is so important, we're not just going to give it's not just like a get out of jail free card if there's like a good reason, like, well, we're open on Saturday, so you got to work. So here's what the Supreme Court, they articulated what came to be known as the Sherbert test. And it's, in other contexts, kind of known as what we might call strict scrutiny, which is a really high burden upon the government. So the question is, has there been a substantial burden by the government on a person's free exercise of their religion? Yes, they didn't get this benefit that was otherwise available to other people. Okay, well now the burden is on the government to show two things. The government has to show that they have a compelling interest and that their action is narrowly tailored. So it's, again, forgive me, it's kind of a technical thing, but this was a really significant decision that established a very, very high threshold protecting people of faith. So that's the kind of the first significant religion clause case in the modern era. The next one I want to just touch on briefly, Lemon v. Kurtzman, 1971, was an 8-1 decision. This was not a free exercise case. This was an establishment clause case. And this one had to do with a statute in Pennsylvania that wanted to fund teacher salaries at non-public schools. Which I kind of like the sound of that, Catholic schools, right? Well, they actually ended up saying in the end, like, no, because there's a lot of, not just Catholic schools, but religious schools here. And the Supreme Court said this isn't allowed. It came to be known as the Lemon test, but there are several factors. Here's what the Supreme Court said, is that the statute must have a secular legislative purpose, that the principal or primary effect of the statute must neither advance nor inhibit religion, that the statute must not result in excessive government entanglement with religion. And this was the law of the land, kind of jurisprudentially speaking, for many years. It's come under fire in recent years with some other significant cases that I'm going to talk about in a minute. But this kind of brings us up to what we can identify as sort of the culmination of modern free exercise religion clause jurisprudence, a big decision in 1990 called Employment Division versus Smith. And I don't know why it's another unemployment law case, but it is. There's a gentleman in the state of Oregon who was fired from his job because he was arrested for smoking peyote. It sounds kind of reasonable, doesn't it? You do drugs, you get fired. Well, he said, hold on a second. I've been a practitioner of this traditional Native American faith for a really long time. I smoked it in the ceremonial context, et cetera, et cetera. Okay, well, it's drug use. What's going on there? But, well, free exercise. We can kind of see how these things are in tension, right? So in a 6-3 decision authored by Justice Antonin Scalia, who is kind of known as this conservative lion of the court. This case ended up being his most criticized case among people who were otherwise his friends. This is what he wrote in this case. It's a permissible reading of the free exercise clause to say that if prohibiting the exercise of religion is not the object of the law, meaning we're not trying to persecute your religion, but if it's merely the incidental effect of a generally applicable law. So if the law is just meant for everybody, not targeting you, then the First Amendment has not been offended. What this did, and I know this is technical stuff, but Sherbert was up here. It was like this huge bar that the government had to clear, and it was really favorable to people that had free exercise claims. What Smith did is it brought the bar significantly down. So it's important. This was not a popular decision when it was issued. Justice Scalia, recognizing that it wasn't going to be popular, he said, look, Congress, if you happen to disagree with this particular standard of review that's being applied to these clauses, you can statutorily modify it. He said that in his decision. So they did. This leads us to something known as the Religious Freedom Restoration Act. Again, don't worry about what it says. I'm going to explain it. So the Religious Freedom Restoration Act was passed in 1993. This was a big political issue at the time because there was bipartisan dislike for the Smith decision. And what the Religious Freedom Restoration Act did was it essentially reestablished Sherbert in statute rather than case law, if that makes sense. So it reestablished strict scrutiny, meaning first question is, has the government burdened somebody's free exercise? And if so, then the government has to prove compelling governmental interest. It's narrowly tailored, the least restrictive means possible. So they did that via statute. It was widely supported by advocacy groups from all over the spectrum, including Jim Bopp of National Right to Life on one hand, and the ACLU on the other hand. It passed by a unanimous voice vote in the House in 97-3 in the Senate, and was quickly signed into law by then President Bill Clinton. It's great, really, really good. It's still law of the land, although in recent years, including this year, congressional Democrats have been seeking to carve it out from some of their proposals, including the Equality Act. So that's the law of the land, which is great, right? So at first it's applicable to all federal government and all state government. The next significant case is Bernie versus Flores, 1997. So 4 years later, the Supreme Court said, well, actually, this doesn't apply to state governments, which kind of left us in a lurch for quite some time, which has left a patchwork kind of quilt of application in various states. Continuing with kind of the case law, we're going to talk about 4 more cases here and then move on. So thanks for bearing with me as we're back in the classroom. In the last several years, there has been just a slew of, there have been several very, very important religious freedom cases. One of the most memorable for people, just because of some of the, frankly, some of the visual, starkly visual images involved, was this Masterpiece Cake Shop case involving Jack Phillips. He's a baker, and he'd been serving a same-sex couple for many years at his bakery. They always come in and buy cookies or muffins or whatever out of the case. But one day they came in, and I think it was following Bergefell versus Hodges, which is the 2015 case that effectively made same-sex marriage the law of the land throughout this country, a 5-4 decision. And they said, okay, we don't just want some generic cookies out of the case, Jack. We're gonna have a wedding ceremony. We want you to bake the cake, and we want you to write this on top of it. And he said, I can't do that. It's just a matter of my faith. I can't. You're welcome to buy something generic out of the case, but I'm not going to actually use my creative abilities to contribute to a message that I just, in my religious conscience, I don't agree with it. This act was unlawful under a Colorado statute that said if you're a public accommodation like a restaurant, a baker, etc., you got to serve everybody who walks in, and he got sued. It was a very, very narrow decision, and it was a good decision, 7-2, which is it's not a 5-4 split, 7-2, but it was on very, very narrow grounds. And the reason it was narrow is because the Colorado Civil Rights Commission, when they were prosecuting this case, they said some really nasty things about religion. So what the Supreme Court said is that some of the commissioners at the public hearings endorsed the view that religious beliefs cannot legitimately be carried into the public square or commercial domain. They disparaged Phillips's faith. They disparaged it as despicable and characterized it as merely rhetorical. They compared his invocation of his sincerely held religious beliefs to defenses of slavery and the Holocaust, end quote. So they said, well, we're not going to get into his free speech and free exercise claims. What happened was that there was an impermissible hostility that they showed towards him. Just very, very, very mean because of his religion. That was a really big case. One I briefly, the year prior, Trinity Lutheran, another big one in the news. This had to do with shredded rubber that was in playgrounds down in Missouri. The state program said, hey, anybody can apply for the shredded rubber, put it in your playground. Except for religious schools, because we can't support religion. And the Supreme Court, another 7-2 decision, said no, that violates free exercise clause. If it's a public benefit available to everybody, it's got to be available to churches too. If you're picking on them just because they're a church, the court says that's odious to our Constitution, cannot stand. Okay, 2019, another 7-2 decision. You see what's happening here. This was a big case, the American Legion versus the American Humanist Association. Remember this? Maybe you saw in the news, there was this big, they called it the Bladensburg Cross. This big, like 20 or 30 foot tall cross in Bladensburg, Maryland. And it was at an intersection. It was built following World War I to honor fallen servicemen. In the 60s, it was transferred to the state, so it's now state land. And so the question was, well, is this an establishment of religion? We're going back to this Lemon test, which is actually kind of stiff arm religion quite a bit. And the court ended up saying, no, the Lemon test doesn't apply here. This is actually, 100 years have gone by, really? 100 years have gone by, and you want us to tear this thing down now? That would, as they put it, that would create the appearance of an aggressive hostility to religion, which they don't want that. So they recognize that over time, like these religious symbols, even if they're on state or government property, they're actually important to the identity of a place. And they recognize that there are lots of purposes to this sort of cultural identity of a place. Okay, there's a religious character to the symbol, but it's also to honor the fallen dead. It's far more than that. And the court said, we don't really think we can step into identifying what those are purposes. So they let the cross stand, which, thank goodness they did. Imagine how many public displays of faith in one measure or another would have been under attack across this country. So, good decision. Espinoza versus Montana was a 2020 decision. This one is highly significant for South Dakota. This one had to do with what they call a Blatant Amendment. And I'm going to show you in a little bit the language of our own state constitution, which is what we call a Blatant Amendment. Blatant Amendments were popular in the late 19th century, and they were essentially state constitutional provisions that made it very, very clear that no public funds, zero public funds, may go to a sectarian organization. And historians, there's a really broad consensus that sectarian organization meant Catholic. The roots are in anti-Catholicism in the late 19th century. In Montana, they had a tax credit scholarship program that it was for kids. They could get a scholarship to go to a non-public school. And the Attorney General of Montana, the legislature of Montana, they were agreed that, look, don't worry about a Blatant Amendment, this can go to any kid. The Department of Revenue, which was in charge of implementing the program, they said, no. We actually, if it's a kid that wants to go to a non-public school that happens to be a religious school, sorry, they don't qualify. See, we've got this provision in our state constitution that says so. There's a lawsuit that ensued, and so it brought into tension, okay, these state Blatant Amendments. Generally, states have the authority to, have their own constitutions, but the federal constitution, federal supremacy, is there conflict between a Blatant Amendment and the Free Exercise Clause? And the court, in a pretty narrowly decided decision, 5-4, it was authored by Chief Justice Roberts. The court said, can't do it. Violates the Free Exercise Clause. Here's what he said. He said a state doesn't have to subsidize private education, public, non-public, or non-public education, whether it's Christian, otherwise it doesn't matter. They don't have to. But if they do, it can't disqualify some private schools simply because they happen to be religious. So if it's going to be open to non-public schools, it's got to be open to all. Well, what that means for us is that our state constitution's Blatant Amendment is a dead letter. I spoke with one of the lawyers who litigated this case I do like a weekly radio show, and I asked her, what's this mean for South Dakota? And her exact words were, your Blatant Amendment is a dead letter. You can act like it's not there. The Supreme Court's invalidated it. Okay, that brings us up to our last case. Thank you for bearing with me. You're such good students. This is a big one. Fulton versus Philadelphia. This is 2021. It was just decided this year. This was a highly significant case that ended in a 9-0 decision, which is big, right? Very big. 9-0. Like never get 9 justices on contentious cases. So the facts in this case, it had to do with Catholic social services in the city of Philadelphia. They've done adoptions forever, and the court recognized the Catholic Church in America has been involved in adoption, foster care, caring for orphans for 200 years. It's just part of what they've always done. It's part of their religious mission. Well, the city of Philadelphia adopted an ordinance not unlike Colorado's problematic statute in the Jack Phillips case. It said, look, if you're going to be in the business of adoption and foster care, and if you're going to work with the city, you have to be willing to place children with same-sex couples. And Catholic Social Services, I should point out too that in other places, Catholic Social Services have they've shut down in places like Massachusetts over issues like this. But in Philadelphia, they said, look, we're not going to do that. We will have to close. But thankfully, they initiated a lawsuit that made its way to the Supreme Court. And the Supreme Court found for them, 9-0 decision. It attacked Smith. So remember going back to 1990, it's the Smith decision, which took Sherbert, took it down to here, as long as it's generally applicable. Then we got RFRA, but okay, now RFRA's on shaky ground, so this is actually really important when these things come up in the court. The court didn't overrule Smith, and it didn't actually even, in its majority decision, in the biggest concurring opinion, it didn't even attack it there. And the reason it didn't is because there was a very slight exception to the Philadelphia ordinance. They said, well, there's an exception there, and you guys didn't use it, therefore it's not a generally applicable law. So because it's not a generally applicable law, we don't have to use Smith down here. We're going to use strict scrutiny. So they left Smith intact. But the reason this is such an important decision is because there are several concurring opinions. In one of them, it was signed by Alito, Thomas, and Gorsuch. They joined in the judgment. So they said, we think this is the right result, but we disagree with the reasoning and how to get there. We actually just think Smith has to go. Smith is not workable. It's got to go. Go back to Sherbert. That's the way we ought to proceed. Several other justices, so Barrett, Breyer in most of it, and then Kavanaugh, in another concurring opinion, they said, look, Smith is really, really shaky. We don't think it works. We're not sure what would come next, but we don't like Smith. And if you've done the math with those two concurring opinions, that's at least 5 justices that don't like Smith. So that's 5 out of 9 is a majority, which means that Smith is, its days are numbered, we hope. Which again is really, really important because, as I kind of alluded to earlier, congressional Democrats have been pretty aggressive in attacking the federal RFRA. And it's not secure. Okay, well done. Through the federal stuff. Okay, so remember I said this Bernie case? We're going to go to the states now. This Bernie case in 1997 said the federal RFRA does not apply to the states. So the map on the left there, I think 21 states, including South Dakota now, those 21 states have a state RFRA within their state statutes. Religious Freedom Restoration Act. South Dakota just passed its bill this year. I'll give you details on that in just a second. The map on the right it's 31 states that have essentially a Sherbert standard, a strict scrutiny, like this is the gold standard. 31 states have this within their constitution, either explicitly or through judicial interpretation. You'll notice that South Dakota is not one of those 31 states on this map, and that's simply because our courts have never considered the question. So it might actually be there, but our case law is silent on the question, and will probably remain silent for a very, very long time now that we have a statute. They won't need to answer that question. So that's where RFRA is at in the states. Okay, quick overview of the South Dakota Constitution. The South Dakota Constitution mentions religion and conscience a few times. I'm going to read them. I know they're eye-charts. Here's what it says first. The right to worship God according to the dictates of conscience. And that word really striking, conscience. To worship God according to the dictates of conscience shall never be infringed. No person shall be denied any civil or political right, privilege, or position on account of his religious opinions. One of the reasons I think that word is so striking is because it's not defined anywhere. We're going to talk about that in just a minute. So next, that bottom one, that's our Blaine, that's one of our provisions that fits in the Blaine Amendment category. No money or property of the state shall be given or appropriated for the benefit of any sectarian or religious society or institution. Okay, so no shredded rubber for the playground, even if it's available to everybody else. We do have a very nice tax credit scholarship program here, by the way, that's been functioning well for several years. That's our Constitution. A couple things in our statutes, and if you go on the state website and punch into the search box religion or religious, you'll find dozens upon dozens upon dozens of statutes that mention religion. It's just evidence that this is part of who we are, and our laws need to recognize that. A couple things I just picked out. So Chapter 20, the top one, that's it's what they call a non-discrimination statute. It's the sort of statute that Colorado used to go after Jack Phillips. It's the sort of ordinance that the city of Philadelphia used to go after Catholic Social Services. Our state statutes explicitly list what the protected classes are, protected categories. It's race, color, creed, religion, sex, ancestry, disability, or national origin. So you can't get fired because of any one of those things. Chapter 22, I found this one interesting. This one actually makes it a criminal misdemeanor to force somebody to compel somebody in the practice of religion. We're all free to choose this under our civil laws. And then the bottom one. This is a really interesting one. I know, forgive me again, I know you can't read it. This one doesn't mention religion. But this is kind of back to our original story. This one says that any healthcare person, they're protected from being forced to participate in abortion. It doesn't mention religion, doesn't mention conscience. It mentions that procedure specifically. One of the problems with this particular statute is that there's no remedy. Like, what do you do? And I asked our state court system, has this ever been used? Has this ever been prosecuted, enforced? Has it ever come up in court? The answer is no, it's never been used. One of the reasons that is, if I'm in a healthcare provider's shoes, I want to know, okay, what are my options here? What's my remedy? What am I asking the judge for? Because we did get testimony on the bill last year that this is actually happening in South Dakota. Okay, those are our state statutes. Big things in the last couple of years, some things that have been added to our state statutes. In 2017, our legislature passed, and our governor signed Bill 49. Is this still working? Maybe a little closer. It's adoption protections for faith-based providers. So they're free to actually follow their faith in how they place children for adoption. The vote in the Senate was 27-8. The vote in the House was 42-20. That was 2017. And I actually just yesterday was visiting with a woman named Kristen Conzet, who is one of the 42 yes votes in the House at the time, and now works for Catholic Social Services in Rapid City. They do adoptions, and they don't place children with same-sex couples, as a matter of faith. More recently, this was, I'm going to tell you what this says. I know you can't read it, forgive me, a little further than I expected. So this is Senate Bill 124. This was passed into law this last year. And what this says, Section 1, it's the Sherlock Standard. It's federal RFRA, it's strict scrutiny, which we didn't have this in our state statutes before. So to have this now is monumental. We were one of those gray states that was not protected before, and now we're colored in. So it says that the government has this really high threshold to meet before they can burden religion. They've got a compelling state interest, and it's got to be narrowly tailored. This bill really just flew through. It passed the Senate unanimously, 35-0. Thank you to our Senate. And over on the House side, 64-3. Which not many bills that kind of touch on, we've been talking, I mentioned tonight some kind of difficult things, hot topics, tension with some LGBT issues, and this stuff is always kind of hard. But one of the things that I think the legislature recognized this year is that our country's been through a rather difficult year with COVID, And thank God this hasn't been the case in South Dakota, but in other parts of the country, we've seen Orthodox Jewish neighborhoods in New York City completely shut down. You can't leave your house. We've seen some places, bars and casinos open, but meanwhile, churches are closed. And I think there was a real recognition by our legislature that this is just part of who South Dakota is, and this is important. We need to protect it here into the future. The second provision says that that religious conduct may not be treated more restrictively than secular conduct of reasonably comparable risk. This is sort of another cushion to add in there. This is what legal scholars would call the most favored nation. So you gotta treat religion just as well, if not better, than everybody else. And then third provision says, well, especially if there's some sort of alleged economic benefit, you can't shut churches down just because they're not money makers or businesses. You gotta treat them well. So big thanks to our legislature and to Governor Noem for signing Senate Bill 124 into law. Representative John Hanson, Senator Lee Schoenbeck were sponsors of that bill. That brings us up to, can we advance it one slide, please? Advance. I think I'm running out of, this concept of conscience. Let's talk a little bit about conscience. George Washington. He counsels us to labor to keep alive in your breast that little spark of celestial fire called conscience. What is it? My proposal, here's what I submit to you. It's not defined. George Washington doesn't define it. Our state statutes don't define it. So, what is it? We actually need to think about what this thing is. Here's my proposal to you. That it's that really special place in the core of our being where you can go deep in your own heart and where you can actually come to know what is right and what is wrong. It's the place where you come to know what is right and what is wrong. When you come to know that, I submit to you, you have to follow it. The Catholic Catechism, the words that it uses are to, if you disavow your own conscience, if you don't follow your conscience, that's to condemn your own self. Now, it's not to say conscience means do whatever you want. We have an obligation, a duty to form our consciences, right? With right reason, with what we know to be the good willed by the wisdom of God. We have a duty to form our consciences in accord with the truth. That's how we exercise our freedom well, right? So that's what I propose to you, conscience is. And this was important because this last legislative session, there was a bill, House Bill 1247, that would have protected in a really robust way healthcare professionals that have an objection in conscience to certain medical procedures. It would have permitted them to say, I'm not going to participate in that. And it left it a bit open. It didn't spell out what the list was. One of the reasons for that was really pragmatic. 5 years ago, who would have thought that we'd be talking about mastectomies in the context for which we're now talking about them? But this was a hard bill. The healthcare lobby mobilized against it. It was defeated in the House. And I say that with all affection and charity for my friends that are working for healthcare, but I think there was a concern that this was going to cause a flood of litigation. There's going to be all sorts of frivolous lawsuits, et cetera, et cetera. And these are real questions that need to be worked through. But I want to take you back to that first question. Imagine you're a nurse. Imagine you work in this hospital. Imagine that's your daughter. And imagine the mastectomy that she shows up to assist on in the operating room isn't to remove metastasized cancer. It's for another purpose that she has an objection to in conscience. Now, the reason this is really important, and the reason this bill was brought, is because the writing was on the wall. we had a new president who it was known was going to nominate this man for his Secretary of Health and Human Services. This is Xavier Becerra. Xavier Becerra was previously the Attorney General for the state of California. He rose to some fame in the legal community for getting his name in a really big free speech case, NIFLA v. Becerra. In the state of California, as Attorney General, he tried to make pregnancy help centers advertise for abortions on the walls of their facilities. He lost. He also became famous for repeatedly trying to force Catholic nuns to cover abortifacients, contraceptives, and sterilizations in their health plans for their nursing homes that they operate. He lost, but that's what he's trying to do. And this is the man that we knew was going to be the Secretary of Health and Human Services and is now our Secretary of Health and Human Services. So that hospital that I showed you, the nurse worked in that hospital. She had a claim going through the federal system, and it was asserted under what we call the church amendments. These are federal conscience protections, very broad amendments. They protect religion and moral belief. They don't list out what specific procedures, just like 1247 didn't. Very, very broad. The previous presidential administration agreed that she had a valid complaint, and they were advancing it. It was in federal court. 2 weeks ago, at the request of Xavier Becerra, the Department of Justice requested that the court dismiss that case. That woman has no recourse. So that's the primary purpose of House Bill 1247. It's not necessarily creating rights that wouldn't otherwise be there. These protections are in federal law. They're not being enforced. They're not being enforced. There's no certainty that they will be. Earlier today, I spoke on the telephone with a man named Roger Severino. He was the director of the Office of Civil Rights at Health and Human Services in the previous administration, and I asked him, was this Vermont case, is this just kind of a one-off? And he said, buckle up, there's more coming. So that's the argument, is simply to give people rights in South Dakota that they can exercise at a courthouse near them, rather than to have to go to Washington, D.C. So those are conscience protections. Kind of end with, what's next for this issue. I was recently visiting with somebody from out of state who works in healthcare, a friend who was visiting, passing through, and was just sharing a little bit about the talk I was giving. I did the same thing in Rapid City, and he said two things. First, he said, I'm sure glad you're doing what you're doing, which is great. I'm happy to do this work, but the heavy lifting doesn't get done unless we all have to want it, right? Citizenship has duties for all of us. So I kind of resist that sort of implication a little bit, that the advocacy groups, they'll figure it out. The second thing I asked was, hey, do you get emails from so-and-so, my counterpart in his state? And he said, yeah, I don't really read them. I said, come on. If a bill like House Bill 1247 is going to become a reality in the future, it's going to take widespread engagement. So I want to thank you very much for your attention, and I'm happy to take questions. Ask me some hard ones.
I know you haven't went so far as to discuss the issue of the vaccination process, but locally we have Sanford who's taken a position, and it appears in the public's eye that there is no recourse for a nurse that's showing up at the hospital, and that's a little bit different situation. It's an employer situation versus a religious freedom thing. But I guess, would you address the issue of, obviously Sanford has decided what their options are, and their directive is very clear. There is no option. If you don't get vaccinated, you're gone. Now, in the public's eye, they try to squelch the idea of the exceptions of medical and religious?
Great question, and I want to speak maybe just broadly and then specifically. So broadly, principles of religious freedom and rights of conscience, especially in religious matters, these are rights that we all have, and they should be respected by all others, regardless if it's the government or big tech or big pharma or big whoever, or even a small business. I mean, it's civil law is one thing, but these rights they're important natural rights. God gave them to us, so they should be respected by all. The second thing I want to just speak particularly to is large employers with more than 50 employees, they are bound by Title VII Civil Rights Act. So we talked a little bit about some of these non-discrimination statutes that, like at the state or city level. The Civil Rights Movement, 60s, resulted in the Civil Rights Act, and part of that is Title VII. So employers do likewise have constraints placed on them vis-a-vis somebody's exercise of their religion. So the question is, if a person has a religious belief, what they do is, under Title VII, they request an accommodation. That's what they do. And then the employer there's kind of a whole series of case law on how that works out. But the questions that an employer is entitled to ask in response to somebody who asserts that claim, they can ask two things. They get to ask, is this claim religious in nature? And is it sincerely held? Those are the two questions. So they don't get to ask, well, you're a Jew, show me where it is in Jewish teaching or Jewish scripture that it says that. They don't get to ask that. Your employer and the government are not the arbiters of what your religion is, nor should they be. They don't get to delve into veracity. All they get to ask is it religious in character, and is it sincere?
I'm sorry, what's the second one?
Is it sincere? Is it sincerely held?
Sincere.
Is it a sincerely held religious belief? So I guess what we would encourage, and the bishops of South Dakota did put out a statement on this topic last week, where they just tried to articulate some of the principles that we can discern within Catholic teaching. And they did encourage that these principles be recognized by public and private entities. They're natural rights that we all have. They're not given to us by government. Maybe one thing I can say too about this, just the question, it's a very good question of vaccine requirements. I think it's apparent to everybody that there are a lot of passions on this issue. And so as Christians, I think it's one of the things that we can offer witness to in the world is just to be like really give witness with joyful charity, regardless of where you shake out on it, but to have an extra measure of grace and generosity with people, because it's hard, you know. You want to do this, you're evil. Well, you don't want to do that, you're evil. Let's take a deep breath. Yeah. Well, I just want to thank you all. I'm going to stick around for a couple more questions, but be respectful of Norman's clock. Thank you so much for your time and attention.